Okay, and as I let people in now, I may repeat myself a couple of times just to let people know. Don't forget to put your LinkedIn URLs in the chat. I will save the chat as well and post it in our group. And anyone who's comfortable sharing their email address, if you could do that, that would be helpful, because going forward, I want to be able to send out a group email some way, shape, or form. I'm still going to keep the meetup group running, but I think I want to try to coordinate as much as possible, especially now that we're losing the Yahoo group. So without any further ado, I don't want to take away the time from the presentation. Audrey, why don't you take it away? And if you have any questions, I think she'd appreciate it if you ask them at the end, and take it away.
Okay, I'm going to share my screen. Everybody see that? Yeah, can everybody see it? This one right here?
Yes.
Okay, perfect. If I may I ask everybody to please mute yourself so that the background noise doesn't interfere with everybody being able to listen. Thank you so much. I really do appreciate that. Anyway, hi everybody. I'm Audrey Glove Dichter. I'm an attorney. I'm a solo practitioner, and I own my own practice. So like possibly all of you, if not many of you, I am a small business. And I focus on advertising, marketing and promotions law, and intellectual property and privacy law. I've been on my own since October 1999, so it's been, a while. And anyway, for our purposes, I have to tell everybody what I say today is just general legal information. Nothing that I'm going to say is legal advice. If you need legal advice, please reach out to me separately and privately so I can protect your privacy. All right. So many of you, if not all of you, have your own businesses. And I don't know who here knows about advertising, marketing, promotions law, but the bottom line is if you have a business website, this field of law affects you and applies to you, regardless of how big, how small, regardless of product or service, regardless of how much money you make or don't make. It doesn't matter, because technically, when you have a website, you are advertising nationally and internationally. So let's talk about advertising law. Just this is going to be a quick review. If I don't answer your questions during the my presentation, I'll take questions after. And if not, if we run out of time, feel free to reach out to me. Okay, so advertising law. It's basically protection of consumers against false, misleading, fraudulent claims or unsubstantiated claims. And of course, we have different ways of enforcing advertising law. And we first start with the Federal Trade Commission. But just so that you know, just about every federal agency has their own rules on advertising law. So when I review a campaign, either in English or Spanish, that's where I start. I start with the Federal Trade Commission because that's our main umbrella. And then from there, I move on to state laws, depending on what you want to do. But I also review other federal agencies based on your product or service according to what we need to accomplish. In this field, we also have we have the federal agencies for federal law. We have state agencies, because every state under the Attorney General's office, they have a consumer protection agency. And they may call it different names, but the bottom line is they do the same thing that basically the FTC does. So then we have case law, and that again could be state or federal. And then, of course, there are some instances where we have local jurisdictions also enforcing advertising issues. For example, I have a case here called New York City versus Ballyhoo. And the interesting part about this case is that it was New York City, so it's a local jurisdiction enforcing advertising law. And basically, what New York City did was they sent this agency, Ballyhoo Inc., several letters. Ballyhoo decided to ignore them, so they got sued and they lost. So the enforcement action here, and the problem that what they were doing that was wrong is what they did is they took Broadway sized billboard, you know, one of those really big ones and really bright and colorful, and put it on a barge. And then they parade the barge up and down the river during rush hour traffic, and it was very distracting. But not only that, it was against the zoning rules. So last year, the judgment came in on October 8th of 2019, and they were required to pay $100,000 fine, and they had to stop doing what they were doing. And that's what happens when you ignore these letters. So let's talk about what are some of the examples here, because you could probably see them. These are some of the basic issues that could either bring in a lawsuit or a letter could be triggered by a federal agency, including the FTC. And then, of course, we have all the self-regulatory bodies. So the biggest thing about advertising law is claim substantiation. Can you prove that what you say is truth? Hence, truthful advertising. And there's a lot that goes with that. So it's required that you have a reasonable basis to support or prove the objective of your claim in your campaign. And the FTC law requires that your campaign be truthful before you launch a campaign publicly. How do you support? Okay, so you support in different ways. One way is running studies or doing tests or doing surveys. So it depends on what your product or your service is. It depends on what we're going to need to support the claim. Then there's puffery. And puffery is obviously a hyperbole, an exaggerated display. So the question becomes, is it puffery or is it a claim? And this is a usual question when lawsuits come up. So let me give you an idea here. So native deodorant, probably many of you have seen native at Walmart and Target and everywhere else, right?
Look at the size of the basket.
What? Oh, sorry. Okay, so native deodorant, they started off with basically a zero marketing budget. So they did their own advertising campaign. In about 2 years of being on their own, they got on the radar and then they got challenged, not sued. And the basically is that their claim was that they could absorb underarm wetness and provide effective protection against wetness. However, they lost the ability to make that claim because what they had done is they took testing from other people and they said, well, this ingredient works here and this ingredient works there, so let's just put them together and assume that it's going to work. But at no point did they do any testing of their own product to show that when you put those two ingredients together, it's going to actually work the way they intended it to be. So they lost that because they didn't have a way to support their claim that, it did absorb underarm wetness because they never ran the test of these two ingredients together. Let's talk about humor. Comparative claims are very, very important. So if you're going to if you're going to compare your service or your product to your competitor, just be very well aware that according to the National Advertising Division, it doesn't matter how funny your ad is or how, the exaggerations that you may use, advertisers still not relieved from its obligation to support the messages in your comparison, especially if you're going to be disparaging somebody. You better know that your competition's watching, and if you disparage the competition will come after you, and you're going to have to support the claim that you're making, that you're better, and why are you better. So basically, you should generally specify exactly what the ad is comparing against to avoid making a broader claim that can be supported. And for example, I'm going to use myself as an example. Okay, I'm an advertising lawyer. So if I say I'm the best advertising law lawyer in, you know, on the planet, well, that's kind of difficult to prove because how many advertising lawyers are there on this planet? And I only do US advertising law. So then how many advertising law the attorneys do US advertising law, right? So it becomes almost impossible to support that claim. So that's puffery, right? Because I can't support that. How about if I say, I'm the best advertising law attorney on the East Coast of the USA? Okay, so now we have an issue, right? Because now I have completely narrowed that down into a geographical area in a specific field, right? So then I would have to do some kind of survey or something to support the fact that of all the advertising law attorneys on the East Coast of the USA, however many there may be, I have to come up as number one, or I'm well known in the field, or something to support that claim. So that's no longer puffery. Now that has become a claim.
Okay.
Um, so now let's talk about advertising to children. And advertising to children has their own very special rules. There, we have what's called the Children's Online Privacy Protection Act, also known as COPA. And COPA is very, very important because it gives us the do's and the don'ts of what you can and cannot say when you advertise to kids. Kids, and the purpose of this is to protect the kids because kids are young and they can't think or process information the way us adults do. Excuse me. So COPA protects kids under 13. However, a little tidbit here. When it comes to privacy of kids, there are certain parts of the CCPA, the California Protection Act, that protects kids 16 and under. So that's something else to consider. So anyway, so talking about COPA, for example, what they got to do is Facebook. I have two kids. Anybody who has kids will probably know that, it was easy for these kids to just lie about their age. They would just figure out what year to put in, and then they were able to circumvent whatever there was. So Facebook got in trouble for that, but they went ahead and changed it and then modified the mobile app to improve the mechanism to prevent underage users from circumventing the age screen. Now, green, when we have green claims, what does that mean, right? So when you make a green claim, how is it green? Are we talking solar? Are we talking a hybrid? Like a hybrid car, is that green? And there's different rules that specify what does green mean. It depends on what the product may be. Made in the USA claims has been, there's been quite a bit of litigation here. And basically what you need to keep in mind is that all or virtually all is the standard, all or virtually all the components and the labor are from the USA. So we have a great case here because New Balance, the sneaker company, what they did was they took a sneaker that was pretty much made abroad And they put the label made in the USA and marked it up by a ridiculous amount of money, right? And then they got sued because they got sued by the consumers because they found out that 30% of the tennis shoes that they were buying were only 30% of the shoes were made in the USA. And here the standard is all or virtually all. So anyway, New Balance got in trouble and they ended up having to pay a settlement of $750,000 for fraudulent and misleading, deceptive advertising. Natural and organic claims, same, lots of litigation going on here. And basically, it's if it's generically modified, does not meet the standards. So, for example, True Organics is a company that got sued because they were using the USDA organic logo certified. I don't know if you know about that, but there's a logo that has to be used because you have to meet certain particular standards to be organic. And what happened to this company is they got prohibited from selling the products. They had stopped selling products through third parties like supermarkets instead of just online. And they were given a $1.6 million judgment. And then on top of that, if they intend to sell anything, everything has to go through the FTC to be approved before it can go live. So let's talk about promotions. There's sweepstakes, contests, and giveaways. So for sweepstakes, you need to have a prize, a chance, and a consideration. For contests, you just need to have a prize based on some measurement of skill, and a giveaway is basically your typical buy one, get one. And then for your contest, for example, once upon a time when we used to be able to go see basketball games live, they would pick somebody, that person would come on the court and they were given, I don't know, 5 balls to shoot. And if they made like 3 out of the 5, they would get a t-shirt or they would get something. That's your typical contest. So let's talk about social media marketing. It is major, and we need transparency, material connection disclosures by influencers, and also on online pay reviews. So here, the SEC came after, they charged 2 celebrities for failing to disclose their material connection to the investments being promoted. So they were investing, they were promoting, they were hired as influencers to sell these coins. And one celebrity said, posted on his social media, starts in a few hours, get yours. Don't, before they sell out, I already got mine. At no point did they say that they were being paid, that this was a paid advertisement. And the other one said, the other one posted, you can call me crypto from now on. One celebrity, so one of them paid $614,775 in a fine, and the other one paid $152,725. So the point of that is transparency. If you were paying somebody, an influencer, to sell your product, to talk about your product, you need to disclose that. And there's different ways of doing that. And that's where, these kinds of agreements are really, really important because they need very tight language, and I help with that. Also, when people are paid, like if you work for a company and the company says, go online and write 3 awesome, give me 3 great reviews on our product. Well, again, you're working for the company. So you have to make the material disclosure that you're working for that company. So basically you're getting paid to write those reviews online.
Audrey?
Yes.
I got a question, hypothetical. If someone on LinkedIn posts something that they say they can do, or that they're actually, it's not them, it's a bot or it's someone else that's posting for them. I mean, is there any pushback? I mean, it's kind of like a wild, wild west out there. So how do you really know what you can and can't do.
Okay. I'm more than happy to answer that. Can I answer that at the end?
Sure.
Thank you. Sorry, it's just I got a lot other stuff that I wanted to get through because I want people to understand what it is that we're talking about. Negative options is another field that I don't know if any of you do this, but negative options is the here, sign up for, sign up today, you get 30 days to try it for free and all your money back. And then that person gets charged every month and gets delivered this product every month. And then they have no clue on how to get out of that. Well, that's negative options. And you need to be very, very clear on giving the person a way out and how to stop this. And a lot of people get in trouble for not doing that. And I mean, I have plenty of examples, but I don't want to run out of time. So branding is important. And this is a great case because it's two companies called Pinnacle. One very well-known company in Florida, they were so good at what they were doing that they had clients that came to them to do Super Bowl ads, which, it's the top of the top, right, of the advertising model. And then there was another little company, actually, that was in Chicago, and then a new company started in Florida, and they call themselves Pinnacle. So to make a long story short, what happened here is that Pinnacle Chicago, the old Pinnacle, found out about Pinnacle Florida and did nothing about it until later. They took a couple of years at least to do something about it. And by the time they got to court on this case, the judge said that Pinnacle Chicago needed to change its name because Pinnacle Florida had trademarked that name before Pinnacle Chicago. So this is part of also doing your business correctly. So there's a lot of issues with advertising law, but this is a good example on intellectual property. Are you trademarked correctly? Are you infringing on somebody else's trademark? And this is the kind of stuff I review. Also, when you do your advertising campaigns, can you use the photo that you just downloaded? Can you use that video? Can you use that music? Do you need any clearances? And the clearances to get the proper approval or the proper permission to use those things on your campaign. So you can't just download things and expect not to get in trouble. And a lot of people do get in trouble that way. So it's part of what I check because intellectual property is very much so a huge part of everybody's marketing. Your logo, your name, your tagline, any of that could be an issue. So let's talk about FDA. FDA has many rules of its own, and I don't know anybody out there if you have FDA issues, but this is a great case. I don't know if you guys can see my little RX bar. Okay, so RX bar got sued because on the wrapper, it says 3 egg whites. See? I don't know if you guys can see it. And they got sued for saying 3 egg whites. And again, to make a long story short was, how do you measure 3 egg whites when you have, a bar? Obviously, you're not going to have 3 fresh egg whites. But the point of contention here was, how were these egg whites, was that misleading or not? And the thing is, obviously, no consumer expects to open up a wrapper and have 3 egg whites sitting inside of that particular bar wrapper, right? So the question was, is that really considered 3 egg whites? And it was held that the consumers can see the 3 egg whites on the front of the pack statement on a small protein bar are unlikely to be misled because the product contains dried egg whites. As a result, the claims is substantiated. And the thing is that it was not highly processed. There's different ways of processing food, and that's why I also review FDA rules, because if it's overly processed, then you can't call it eggs, right? But because this particular product was not overly processed, then they could call it eggs. So anyway, there are other issues to consider. Um, let's move forward. Who can challenge you? Everybody and anybody can either sue you or complain to the federal agencies, the state agencies, or bring a challenge. And this is the different ways that they can do it. So the consumers, if you have enough people complaining, they're going to get somebody's attention, and then an investigation is going to be launched. Your competitors, once you get on that radar, your competitors are watching, because if you start taking market from them, if you start taking consumers from them, then guess what? They're going to complain about you, because they want to know, they're going to see what you're doing wrong, and they're going to complain about something. Anybody and everybody who has a problem with your intellectual property usage, like I was just saying, did you get permission to use what's on your campaign? Or what about your own protection? Did you protect your own intellectual property before you went public so nobody steals it? Also, any state attorney general's office, federal government agencies, and like I said before, just about all of them have their own rules. So we start with the FTC, and then we work with whatever else we need to bring in. And of course, the self-regulatory bodies.
Oh, is she gonna get the title?
I'm sorry?
No, there was someone.
Oh, okay. So, and the self-regulatory bodies are bodies that are not tied to any of these others. And there's a national advertising division. There's the children's advertising unit, Carew. There's several of them, and it depends on what the issue is. It depends where you go. And let me tell you something. It is much less expensive to deal with the challenge from one of these self-regulatory bodies than it is to be sued, or in the middle would be getting a letter from either the state or one of the federal agencies. By the way, just so you know, the federal agencies work closely with the state, and just keep that in mind. So what needs to be reviewed? Everything and anything. If it's not on here, include it, because if it's part of your campaign, it should and it needs to be reviewed. And yes, that includes sales and promotions and coupons and contests and sweepstakes and emails and influencers, you name it, whatever you're using, it needs to be looked at just for compliance. Okay, so so here we go again, things to consider. Is it puffery or is it clean? So when you're putting your own website together, or when you're putting your own marketing together, ask yourself, if I'm gonna say this, how am I gonna support that if somebody asks me to support it? And there are rules for everything. Really and truly, there are rules for everything. Be careful about disparaging your competition, because that can definitely come back to hit you. Images, again, a picture can paint 1,000 words, and there are instances where there's commercials, actually, no words, nobody's talking, it's just pretty music, and maybe some wording here and some wording there, and showing it was one vase with one flower, one vase with the other flower, with another flower. And then they showed one product with doing the commercial, and then one product, the competition. And although there was no talking, they lost the claim for disparaging the competition and not being able to support the claims that they were better than their competition. Here's something that everybody tends to forget about. It's not just what you say, it's also your implied claims. What do your pictures say? What does your whole website look like? What is it saying? What is it not saying? What does it look like? What can somebody take away? What is the message that people are taking away from everything on your website or whatever advertising marketing you're doing? Omissions. Just because you didn't say it, it doesn't make it truthful. If there's something you need to say about your product, then you need to say it. Otherwise, an admission is still just being, untruthful. And disclosures, you must have your disclosures wherever absolutely necessary. Okay, so these are important questions. Who needs to review your advertising? So, like I just said, this is a field of law that has no limits. All right. It applies to everybody and everything, period, regardless of size, money, product, service. It affects everybody, especially if you have a website. And a lot of times I get, oh, but I have a CMO, a chief marketing officer, or I have my own in house team. I'm good. Wrong. You're not good. Because the point of that is they're creatives. Their whole job is to be creative, to get you, out there in front of the consumer and get a greater consumer base, right? They're not looking at the legalities of what they're saying or what they're doing. So the attorney's job is to work with with your is to work with the creatives, preferably before you launch publicly, to make sure to keep you compliant and keep you legal. And you want to make sure that you're compliant not just with advertising law, but with privacy law and ADA law as far as your websites are concerned, and of course, intellectual property law. So that's why there's a major misconception that just because you may be working with somebody who is designing your website, they're not lawyers. They're great at what they do, but you should still seriously consider looking at the legalities of what you're doing. Other issues to consider is all campaigns in foreign languages must be reviewed in the languages that they're wanting. So I do English and Spanish. Sometimes I can do French and Portuguese, but my main languages are English and Spanish. And that's because you don't want to lose the consumer. All right. You want to make sure that it's done correctly and that you don't lose the message and this consistency of message throughout, regardless what language this is in. Other issues is contracts. Contracts need to be reviewed by an attorney. If you're working with an agency, they have their own lawyers, or they should, and you have your own lawyers. So each of those lawyers need to be reviewing these contracts to make sure that there's nothing hurting anybody and that it's a give and take relationship and everybody is on the same page. Influencers definitely need major language, advertising law language. And again, like I said before, clearances, agency work, IP ownership, all those are important. Your legal disclosures, disclaimers. For example, disclaimer would be if you are selling cosmetics, but as you very well know, cosmetics are not regulated. They are regulated by the FDA, but they're not approved by the FDA unless they're like OTC, over the counter things. So if it's not an over the counter product, it may be a good idea to put not FDA approved or not necessary to be FDA approved or something of the kind. And again, I use the language very freely as an example. And again, your supporting documentation needs to be reviewed to make sure that you're not going to run into any issues. And again, the whole point of doing all of this before you launch publicly is to protect your business from lawsuits, letters from the government of the state, or getting a challenge. And you're minimizing your legal risk. Because if you end up getting sued and you haven't done any of this legal due diligence, it will be a lot more expensive for you to defend unless you did your due diligence and you can go into court and show the judge everything that you did and hopefully get rid of the lawsuit as soon as possible. And anyway, so my whole presentation is about advertising campaigns in the USA. Okay. If you're introducing products from abroad, just know that those campaigns must be reviewed for US law. Let's talk about websites. Like I mentioned before, your website is your marketing. And because you can't limit where it goes, you are technically considered advertising nationally and internationally. So it's not just advertising law. Now you need to deal with privacy law because it's the who, not the what you're selling, not the where. Doesn't matter. It's the who's on the other side of your website that matters when it comes to privacy law. So now if you have, for example, an EU citizen sitting in New York looking at your website, well, GDPR just attached to you. So you need to be compliant with GDPR. And what about if you have a California citizen or resident sitting in New York? Well, CCPA just attached to you. And you're not going to know unless somebody brings a complaint or reaches out to you. And then if you're not legally compliant, they can file, for privacy law violations. And we discuss intellectual property again. What's on your website? What's on your campaign? Did you get permission or did you protect your intellectual property? Let's talk about ADA law, and that's the American Disabilities Act. Now, I'm not an ADA lawyer, but if I review a website for compliance, I'm reviewing to make sure that it is compliant with ADA because there's been a lot of litigation in that field lately for people who are not legally compliant. And that means you may need to change the font, you may need to do this, you may need to do that. I'm running out of time, so I'm going to speed up. These are the advertising top tips. I'm going to put in the chat the link, so feel free. I'm also going to share the link with Kenneth so he can share it in the newsletter. And okay, I'm going to open up to questions. And this is my last slide. If you want to write down how to reach me, please feel free to do so. Ken, I'm going to start with you because you had a great question. Ken, sorry about that.
Right, one of the questions I had is the general question: how does LinkedIn get into this? I mean, LinkedIn, first of all, you have a profile on LinkedIn, which I don't know if that's considered a website, and all the different people that post on LinkedIn, whether it's one thing to brand, it's another thing to kind of over promote. I mean, how does that get regulated? My question, long story short.
Well, LinkedIn is complicated just like Facebook and everybody and all the other social media platforms, right? Because everybody has their own rules. And this is what takes me back to knowing what are you signing when you sign up for using a social media platform. You need to actually look at the terms and conditions. You need to know the privacy policies, the disclaimers, and everything else within that realm. It's important because, for example, some social platforms, if you post a photo, like your own personal photo, somebody can come along and snag that photo. They have the legal right because all those documents I just mentioned are legal contracts. Okay. So they're legal. And then that means that you can complain and they tell you how to complain. But if somebody comes and takes that photo, you have to go through certain channels after that person. You can't just sue the person, right? Because, for example, I believe it was Instagram that people are allowed to take you. You need to know that when you post things a certain way, not all the way, like if you post it in general public, right? If it's, open to the public, then anybody can use it. But if you're posting it privately, like if I'm only sharing it with my closest friends and my family, you cannot come into my account and steal my photo and share it nationwide.
I know one thing I had to do with my website is I had to put on terms and conditions and a disclaimer on my website so that I could be in compliance with LinkedIn. And I think that's something that it kind of protects you. Anything you do, not that everyone's going to come after you, but it's good to know this. So I'm going to open this up now to any other questions if you want to unmute yourself and ask. Thank you very much
just,
for the presentation.
Just to take that further from what you said,
Sure.
It is absolutely crucial for anybody with a website to have terms and conditions and privacy policy in a cookie banner and your disclosures and your disclaimers, because, like Kenneth just said, it protects you. So if anybody comes back and complains and they sign, they have no access to the website if they don't sign, correct? So if they agree to these terms and conditions and you can prove that they did, then they agree to the do's and don'ts on your website, right? And if they violated those, then what are they going to complain about, right? So it is seriously important. Okay, I'm open for questions.
Okay.
Anybody?
Anybody? Otherwise, I'll keep asking.
Okay.
Okay. So here's the other question I have. What recourse do you have if you feel that the service that you've been utilizing hasn't conformed to what you wanted? I mean, if you normally, like when I do anything, I have a contract signed, but a lot of times things are just word of mouth or emails back and forth. So does an email actually constitute a contract that you've agreed to the service? How spelled out does it have to be? If someone wants to use, let's say, a resume writer, or if someone wants to take advantage of a service, do they have any recourse or any way to appeal or question?
The best way to protect yourself is get it in writing with signatures from all parties involved. It's just that simple. I like emails because it creates a paper trail when I work with people. And even when I get off the phone call, I'll send an email to confirm, just make sure that I didn't misunderstand something. But an email is not necessarily a contract. So a contract in writing that shows the parameters of what the agreement is for is absolutely necessary. Like, I won't work with somebody if I don't have a contract, because they need to know what my fees cover and I need to know what exactly they want me to do, right? Because
And
if you
just
don't,
like when you're you know, replying as yourself, but you're representing an organization, in doing so, whether it's a networking group or something else, this is kind of a gray area. Most people don't think of this legally, but Alex Freund, for those of you that know him, he always says in his presentations that there are some things he can't share because the pictures, he only uses pictures that he hasn't gotten permission to use, which is one reason he won't share his presentation, because legally he's taken something and not given back. So if I use a picture, if I credit the person who did the picture, is that sufficient? Like if I put an artwork or something and say, thank you, X, for this, is that sufficient?
ooh, that's a loaded question, Kenneth.
Well, that's what I'm asked. That's why I'm asking
Okay,
it.
so you mentioned a couple things. First,
Okay.
let's address the first question, which is what? Anna, can I help you? Hello?
I'm muting. She's muted.
Oh, thank you. So let's talk about attorney-client privilege. Okay, so I can't share with anybody what a client shares with me, no matter what it is, right? And it's just not just the law, but it's the ethics code of attorneys. So if somebody asks me, hey, I heard that you're working with someone, I'm like, oh, I can't say whether or not I'm working with so-and-so because I'm not allowed. So I can understand why somebody else would not want to share things, because again, it is attorney-client privilege, and that information, I mean, I would need a subpoena or something
Okay.
serious. Okay, so to answer the second question, that's really difficult because there's lawsuits everywhere on that gray spectrum.
Okay.
And for example, last year I posted about Jen Lo. She saw a photo of herself that a paparazzi posted on social media. So she downloaded it and shared it on her social media, got sued. So she got sued for infringement of copyright for using that person's photo without permission.
So there's a question in the chat. Do you need to set up terms and conditions for a personal profile website, a website only used for job search profile information? I mean, I know my thought is,
have it, just put something on there. Like, I don't even collect any information on my website on purpose, so I can keep it simple. But even I have it because, it better be safe than sorry. And if you're not collecting any information, any what's called personal identifiable information, like me, then you can keep it simple. That does not mean, please, that don't take that to mean go to somebody's website, copy and paste it over, because that is possibly one of the worst things you can do, because A, you're infringing on somebody else's potential copyright, and B, how do you know that what you just did covers your business, right? Because I use those and I make them specify to the business. Like, I make them to make sure to cover that business, and it's not one size fits all.
Don't forget also, everyone, that when you're on LinkedIn, you're agreeing to their terms and conditions.
Correct.
Same thing with Facebook. So most people don't read the terms and conditions because it's dry. It's, excuse me for saying it, attorneys. But if you run afoul, they'll come back and say you violated the TOC, as they say. And
they could pull the plug on your LinkedIn and how bad it is. Maybe you get sued, maybe you get.
I know three people who have lost their profiles and had to get them back because they used automated tools to try to find people. But I don't want to digress. I really would love to hear other people's questions or thoughts.
Well, let me just say real quick about that. Just because you're using automated tools, it doesn't mean that you shut off your brain. And I mean,
but it goes against
the most respectful manner. For example, I like to use Buffer. So I'll plan my LinkedIn posts for as many days as I can, but I don't just rely on Buffer. I will go every morning and check it and double check it, and then I'll post it through Buffer. But it's not like just letting a robot just post for you. You still need to be aware.
I'm sorry, this is a case, I get a lot of connection requests with your boilerplate, and they've been sent through an automated connection request system of some type, and it's a violation of LinkedIn, but you can't prove it. And there's a lot of things. So LinkedIn allows you to report things, but I'm trying to get a sense, and I don't want to monopolize the conversation. You guys must have some questions.
Yeah, nobody has a website here. I find that difficult to believe. Come on, you're business owners. Anybody have a question?
Anyone who's a consultant is a business owner. If you're looking to do consulting and you have a website and you're sending people to it, even if it's LinkedIn, there are some things to consider. And I know we don't all think of ourselves that way, but your website is who you are. And again, it's a little hard for people to think that way, but let's look at it from this perspective that you hire someone to do something and they don't do what you want them to do. What's your recourse?
Not only that, but think about this. Like I said before, the creatives are awesome. And I know we probably have a lot of people here who are website designers and copywriters. But the thing is, they don't do it with the eye towards the law. Their point is helping you get more clients, right? So when you have a website, it's always good to run things through an advertising lawyer. Remember, you don't go to the gynecologist to fix a broken bone, right? So it's exactly the same with lawyers. You can't go to a real estate lawyer to review your advertising campaign or your intellectual property or your privacy issues, because that real estate lawyer has no clue. Just like I'm not touching a real estate closing.
John Sampson.
I have a question also.
Okay, can we ask
Hi, Audrey. John, you want to go ahead?
Yeah, John, I'll ask John a question. John Sampson.
Hello?
Hello.
Hi.
Question. You've got a website, PSG of Morris County.
Yes.
So do you have anything on there about terms and conditions and all the, and the policy?
I'm embarrassed to say I don't know.
So technically, and
Yeah, and I get it. I get
good.
it.
All right, Paul, go ahead.
Okay, so Audrey, thanks for the presentation. I actually privacy professional, so a lot of this resonates with me in terms of mechanisms for cookie management, cookie banners. What's your usual advice in that direction? Because I tend to work with OneTrust. There's also everybody on the call should look at this site. I'll put it in the chat, cookiepro.com.
There's a lot of stuff out there.
Which is a great way just to do an assessment. Everyone can do an assessment of, you wouldn't use this against your LinkedIn, but for instance, John, you would use this for your PSG and Morris County site to get a sense and to help you start to build out, a privacy statement and to select an appropriate privacy cookie banner, which can be as simple as we use cookies. Sorry, there's lots of flavors
about the cookies. Okay, thanks for your question. So there's a lot of really wonderful software out there. The question is, what do you need? What does your business need? There is no one size fits all. There's no cookie cutter. So it depends on what you need. It depends on what we use.
That wasn't a cookie pun, was it?
No.
Sorry.
No. So
bad joke.
What I'm saying here is there's no cookie. No, there's no pun there. But what I'm trying to say here is everybody needs a cookie banner. Everybody needs terms and conditions. Everybody needs a privacy policy.
Michelle, you have a question, Michelle?
Yeah, it's more half statement, half question. I use Hootsuite to publicize our alumni events. I'm always careful to go out to Shutterstock or somewhere to pick my images so that, I'm not infringing on anybody's copyrights. But my question is, going back to Ken's earlier question, if you have a picture that you have permission to post, is there a royalty that you're going to owe somebody for posting that, or how does that work?
Well, that's all going to depend on how did you get the permission, right? Because, for example, when you go to Shutterstock, you have a license and you have to pay for that license to use that photo, right? And also it depends on the license that you purchased as to how you can use that photo. So it really goes back to where'd you get it? What kind of permission? And it's really more like a license agreement. What does the license agreement say? Can you use it just here, or can you keep using it on everything regarding your business, right? And how much do you need to pay? Like a Shutterstock, you download it, you pay for it, you're pretty much done, right? Whereas if you're buying a photo from a photographer, right, and you're getting the license to not infringe, so you're getting a licensing agreement to use that photo from that particular, private photographer, all this language is what needs to be negotiated. And that's where I would come in to help you trying to figure out, okay, well, how much does he want? How much can you pay? And are there any conditions or terms that need to be addressed in writing as to how long you can use it? What limitations do you have in the usage of that photo? So there's a lot to address there.
So Audrey, one other thing which comes up a lot, people put behind their LinkedIn profile, they put pictures and images.
Mm-hmm.
I know my picture is my picture that I had taken of me, but is there if you take basic stock photos, whether it's an image or something, is there any concern about that? If it's just a general background that you found somewhere, whether it's a Google photo or something?
That's going to depend on where you found it and when you download it, what does it say? A lot of times it tells you, you click on the photo, it will tell you whether or not it's free or how much you need to pay and who the owner is. I mean, really and truly, it's really not advisable to just download whatever off the internet and then publicize it, because that's how a lot of people get in trouble and then they get sued for copyright infringement. And there's a lot of case law. If you want me to give you case law, I can give you tons of cases on that. And because that's like on a daily basis, I read about somebody did that. So it's not worth the risk.
And I want to just emphasize, a lot of the stuff may seem like they're not going to come after you, and maybe they're not, but just being familiar with the process is extremely helpful. And I wanted it today to be about just get a sense of what is out there. I mean, hopefully no one's ever going to get sued and no one's ever going to come after you. But at the same time, what if they take something of yours? And that's
Yeah.
what happens more times than not. I've had things taken of mine, other people too. And
So I'm
Right.
sorry.
Go-
There's software that people use to track that. Whether you taking from them or somebody taking from you, there is software for that. So
Can you
FYI, don't take from anybody else. Come up with your own stuff.
Can you post the links in the chat for a couple of those, or do any suggestions?
Um,
Or just send me, or we'll follow up after and I'll post it in the group. For
one,
sure.
I mean, one that I know of that's very popular, it's called Copyscape. Copyscape, all one word. And that one is used in a lot of websites and it's basically a protection from somebody coming to your website and copy and pasting from your website. And if somebody does that, then the software alerts you somehow. And yeah, so it's pretty good. And there's other ones, but that's the one that I know it seems to be pretty popular. And it works great with WordPress. I mean, it's one of those plugins with WordPress. That's the other thing, you guys. Don't just buy the plugins for the privacy or the ADA or the Copyscape. It needs to be massaged. Then just because you're buying it, you can't just rely 100% on it. You need to know what you're buying, and you need to make sure that it is correct for your business. I'm sorry, what?
No, any other questions before we sign off?
I can. This is Anupama. I saw a question in the chat. It's not mine, but I wanted to
Okay,
make
thank
sure.
you.
So Anne Maydu has asked, do you need to set up terms and conditions for a personal profile website? The website only used for job search profile information.
Again, if it is a website, okay, and it's out there in the stream, in the mainstream, you can't not protect yourself, right? Because what if somebody comes to your website and does something not so good? You want to protect yourself, right? So if somebody comes and they accept your terms and conditions and your privacy policy through your cookie banner, then you have just protected the information that's on there, and then you can go after this person for having done whatever it might have been, right? For violating your terms and conditions and
One other question that came up: could a person end up in trouble if you share or reshare an article? It says on LinkedIn or Facebook, you can share and reshare articles on LinkedIn because you're that's what they want you to do. I don't know if the person's talking about if I have a website and I share someone else's article on LinkedIn or something. Ronnie asked if you want to just message me after, I guess, to get a better answer.
Well, it depends on the platform. It depends how you share it. For example, like I share things all the time, but I don't just.
What about, I'm saying just generally articles for any source.
Well, what are you sharing? Just
Ronnie, can you unmute yourself and ask? Because it's probably easier if you do.
Hi, sure. I'm unmuted. Are you able to hear me okay?
Yes,
Sure.
yes.
Yeah, it's just really a general question. we know LinkedIn does seem to want us to share and reshare articles, but is there any possibility that doing that, even if LinkedIn wants you to do that, maybe the author doesn't?
Well, okay. There's fair use, which is a concept in intellectual property, as to how it depends on how it's used. It depends whether or not it falls under fair use. So if all you're doing is sharing an article, not getting paid for educational purposes, right? Then we're all kind of getting a benefit out of that. But let's say you are using the article to get business and you're getting paid, then that's not fair use, right? And I'm being extremely general and extremely broad here, just try to give you a sense of fair use. But fair use is quite limited as to, like, for example, I share documents articles. And what I'll do is I will maybe talk about it in my post, and then in the comment, I'll share the link. So people can't just go read the article. So I'm making the points that I want to make on my post. And of course, I mention that particular, because it's for educational purposes. Whatever I'm posting, it's to help business owners to, be aware of these 3 fields of law that are affecting you, right? So I'm not getting paid for that. I don't get anything out of it, right? It's just exposure. But I always share the link. And if you need to do something more than that, like if you want to present, like use that article at a presentation at a big conference, reach out to me and call me, because at that point we're going to need to reach out and get permission for that, right? That's a totally different way of sharing things.
Thank you. That was exactly the answer I was kind of looking for. And I'm only looking at it from a, sharing to spark conversation or just to point out something interesting, not for any specific other reason, but to participate in a conversation.
Right. So make sure you give credit, make sure you share the link, make sure you give this person all the credit on earth, because you want to make sure that they don't think that you're stealing it, or you're not giving them right credit or whatever. I mean, again, on LinkedIn, if you're welcome to go to my LinkedIn and you see what I post. I don't do the links on the post itself, because when you do that, the algorithm penalizes you and whatever. So I usually post the link in the comments. That's just a little sidebar. Any other questions?
Ken, there is a follow-up to that earlier question, and Madhu, I don't know, she can't unmute, but I'll read it out. She says, I'm not a business owner, but concerned about personal profile. How would I set up terms and conditions? Do I need to request from the website tools, like example, WordPress?
At this point, we're getting into personal-based questions. More than happy to answer that question. Just reach out one-on-one and I'll be happy to answer that. I do usually offer everybody a 30-minute consultation for free, just so that, maybe I can point you in the right direction. But when we start getting to personal questions, I'm going to draw that line.
Okay.
All right.
There's one more question. It's a general one. What about the non-standard backgrounds on a LinkedIn profile?
I think I answered that already.
Oh, okay. Sorry about that.
That's okay.
I'm just getting bagels.
What?
Are you on advisory, Alistair?
I think it's a side conversation.
Nancy, do you have a question?
No.
Okay.
All right.
Oh, no, sorry.
Thank you, Audrey. You answered my question. Thank you so much.
Oh, my pleasure.
Thank you.
Again, I offer that 30-minute consultation just because I'm here to help, so that you guys can protect yourselves and